If I understood you correctly, you said that the Constitution and Florida statutes won't permit us to do this. Is that correct?
I believe that under the Florida Constitution and the Florida statutes, based on some of the court cases out there, as well as the various AGO opinions, would indicate that this type of MSBU would not be approved simply because there isn't a primary or paramount public purpose.
And who do you think determines the primary public purpose?
The Board of County Commissioners.
Okay. And if we determined that there was a primary public purpose, would you argue with us?
I mean, sure. I mean, well, I think that's why I'm here. I mean, this was passed. This was passed by the board back in December for some type of public purpose that we're unaware of until February 3rd. But yeah, I mean, depending on what type of public purpose, I mean, we could argue that there was a public purpose because, you know, one person decided to walk on the seawall today. I mean, but does that encompass the paramount public purpose, the nature? So, I mean, it would be, you know, a variety of factors that would have to be considered.
So you're saying that the Constitution or Florida statutes won't permit us to do it unless we find a valid public purpose.
Well, there needs to be a valid public purpose, but it also needs to still be within the bounds of the law. And the law, as it states in 125, it does not indicate that seawall repair replacement is allowed under the MSBU or the county powers. But again, you know, we've had some discussion on that earlier.
You made the observation, I think, that municipalities have the authority to do this. So now, can you explain to me how or why a state constitution would prohibit a county government from doing something, but allow a city to do the same thing?
Sure. Well, I mean, just the plain language of the statutes themselves indicate that. I believe in the January meeting I brought that up, and I mean, I think when they were drafting the Florida Constitution and the Florida statutes, they specifically didn't decide to list that power under the county government under 125 when they specifically did under 170. That could have been changed in any number of times. It wasn't. I also think that just because a city has the power to do so, it still needs to, again, be within the public purpose. And there is no question really directly of whether or not it's a public seawall or a private seawall. The statute isn't clear on that. I would assume, based on the rest of the statutes, that it's talking specifically about public seawalls, that cities can do things with public seawalls. Again, it's just a little different than what we have here.
You see, here's my problem. I just can't imagine a constitution that would say, you city have the authority to do this, but you county don't have the authority to do this. I cannot understand the purpose of a constitutional provision that would reach that conclusion, and I cannot understand why anyone would interpret it that way.
Sure. I mean, ultimately, that's a question you'd have to take up with the legislators, why they left it in 170 and didn't put it in 125. But, you know, I think the concern here is whether or not, I mean, we're looking at the law as it stands. And we also saw in the Giblins report that there's been no other cases with substantially similar facts that is similar to what we have here today. So again, we have hundreds and hundreds of thousands of miles of coastline in Collier County, in the state of Florida. We have canals all through Collier County, all through the state, and that there hasn't been one instance in 50, 60, 70 years that someone has decided to create or use an MSBU to repair or replace a private seawall. I mean, otherwise we wouldn't be here today. Just the facts don't exist, so that's why this is a new precedent. From what I've been able to tell, and I think what the county attorney has been able to find, as well as the outside counsel report, is that this just simply hasn't been done before. So I think ultimately there has to be a reason for that. And I think based on the facts and the discussion that I've been able to present today and prior, there's a clear reason for that. And I think it's simply because the law just doesn't allow it in its current state.
I think that's probably an incorrect interpretation. I think what they said was that it hasn't been litigated. They cannot find any case where something like this has been litigated. But I understood that there were a number of places where this had been done. As a matter of fact, I think we've done things that are similar. If one looks hard enough, you might find a period that is slightly different or a comma that's in a different place. but the essential elements are the same. But that's and the other thing I would you indicated that the people hadn't been doing their jobs, or else they would have accumulated enough money to do this. I don't think it serves anybody's purpose to try to punish current residents because people in the past might not have created a large enough reserve to do this thing. So that having happened, and we cannot undo that, I don't think that we as a Board of County Commissioners should try to punish them for letting that occur. I think our job is to help them solve the problem. But that's all I have to say, Mr. Chair.